Good afternoon, folks, and welcome to the Tennessee Court of Appeals. I want to take just a few moments before we get started and talk about some preliminary matters. First of all, I want to introduce the panel for this afternoon's hearing. Judge Arnold Golden from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. Obviously, we have experienced practitioners involved in this case, so it really doesn't need a whole lot of explanation, but each side gets 15 minutes to make its oral argument. If you're the appellant, you may reserve up to 5 minutes of rebuttal time, but you'll need to request that from the court after you introduce yourself and before you begin your argument. I want to thank each of you for agreeing to participate in this process. It's new, it's different, and it's a work in process. And we find something out new every time we do it. So it's a learning experience for us as well. But we appreciate you agreeing to participate and allowing us to continue to resolve cases and hear cases. I want to thank Mr. Hevner. He's been the mastermind quarterback of all this and has allowed us to put this together with the help of his staff. I also want to thank the AOC. The technology people at the AOC have been wonderful. They continue to make things better every time we do it. So without anything further, Mr. Hevner, you may call the first case.
The City of Jackson versus Lou Bosco et al.
All right, let's hear from the appellant.
Good afternoon. May it please the court. My name is Vincent Saylor. I'm co-counsel for the appellants Lou Bosco and Bosco Contractor Services, LLC. My co-counsel, Mr. Werner Smith, has asked me to address the constitutional issue that we've raised, and he's going to address the statutory interpretation issue. We would like to reserve 5 minutes for rebuttal, please, if it pleases the court.
And how much time are you going to take as well?
5 minutes, Your Honor.
Okay. All right. You may proceed.
So this case arises from misdemeanor summons that were issued to Lou Bosco individually in the Jackson City Court, asserting that he was violating the City of Jackson ordinances by providing roll-off dumpster services to property owners and contractors for the removal of construction debris. The city has a contract with Waste Management for the provision of those services, as well as residential and commercial garbage pickup, and has enacted ordinances supposedly restricting those services to Waste Management. We have issues with the constitutionality of those ordinances, as well as whether Bosco qualifies under the exemptions to those ordinances. In the city court, Bosco was found guilty of violating the ordinances. He appealed those to circuit court. And in circuit court, Bosco Contractor Services, LLC, which is a Tennessee LLC, which actually operates the business, came in as a third party. It's Bosco Contractor Services, LLC. I'm just going to refer to it as Bosco LLC. It was not made a party in the city court, was not named in the summons, but when the case was appealed to the circuit court, it filed a third party complaint. The way this business works is like this. The contractor or the property owner calls Bosco, Bosco LLC, a truck brings a dumpster, drops it. When the contractor or the property's owner is ready for it to be picked up, Bosco comes and picks it up. Bosco uses the same type dumpsters that Waste Management uses. Its drivers all have CDLs. All of its trucks are insured. There's never been any accusation that Bosco operated trucks unsafely or disposed of debris improperly. In the third party complaint, Bosco LLC asserted claims under the federal constitution and the Tennessee state constitution. The court granted the city summary judgment on all of those claims on the basis that Bosco LLC lacked standing due to not being engaged in interstate commerce. We have not appealed the dismissal of the federal constitutional claims, just the claims under the Tennessee state constitution. And the court's ruling that you have to be engaged.
Let me ask you a question about the constitutional claims. I know that there's been some back and forth as to whether or not y'all are attacking the contract itself or just the ordinance for constitutional purposes. But it's difficult to see how you can separate those two, since the remedy, the effective remedy of determining that that the ordinance is unconstitutional would be that would impact this exclusive contract provision with waste management, which, sorry to be so long-winded, but the point being, how can this constitutional determination be made without waste management being a party to the lawsuit? It seems like they have to be a necessary party because their rights would also be impacted.
Right, and we addressed that issue of the city never brought that issue before the court of them being a necessary party. But we're only challenging the constitutionality of the ordinances, the court not asking to have the contract invalidated. So the court could say this ordinance is unconstitutional, cannot be enforced as to Bosco. That might put the city in violation of its contract, and it might entitle waste management to damages from the city under that contract, but it would not necessarily invalidate the contract.
Well, explain how the ordinance is facially unconstitutional without the impact of the contract.
And we cited at length in our brief the opinion from the Tennessee Attorney General, which did an excellent job analyzing this issue. And basically, this is a common right. And then even if it is a common right and you look at the public good portion, the contract with Waste Management did not go to the lowest bidder. Waste Management was not the lowest bidder. They're charging in excess of twice of what Bosco's rates are. So under that three-pronged test that the Attorney General opines should be applied, is it a public service? Is it a common right? And does it carry out the public good? The Attorney General said, if the charges imposed upon property owners under such an exclusive contract do not bear a reasonable relation to the services provided, a court would likely find an unlawful monopoly exists because the award would not have been made to promote public safety or public health.
But would a finding impact the contract?
I think a finding that the ordinance is just the city's method to comply with the contract. So if the ordinance were not enforceable, the city may be in violation of the contract, but it would not make the contract moot or impair Waste Management's right to seek remedy from the city for violating the contract.
All right, thank you.
Thank you.
All right, sir. You have used your time. We will hear from your co-counsel now.
Morning, Your Honor, or afternoon, excuse me.
Good afternoon.
Your Honor, I am, I see the clock running. This is all new to me. I'm used to standing in front of you. May it please the court, I'm presenting the issues about, within our brief, I'm arguing concerning the statutes. We basically, our issues are, we argue that 17-101-12, 17-103, 1 and 2, and 17-105 of the Municipal Code of Jackson, Tennessee, read as a whole, allow Bosco Contractor Services, LLC, to dispose of construction garbage for contractors and property owners. We assert that those statutes read together allow them to dispose of construction garbage for another business or another property owner. The city of Jackson relies upon the blanket statute, section 17-103, that provides that all trash, including bulky waste, shall be collected by the city of Jackson, and that no one else can pick up the garbage, even garbage or construction garbage in this case, that is on private property owners. Section 17103 is a general statute in that it applies to everybody. However, that blanket statute has several general exceptions. Under the case law that we've cited in our brief, there's basically holdings that when you have a general statute and specific statutes that and the ordinances conflict, the general statutes, the special statutes prevail over the general statutes. The city of Jackson asserts that other than the actual producer or owner of the construction garbage, that nobody can haul off the garbage except for them. I want to jump into the first statute that is an exception, I believe, to the general mandate that the city of Jackson controls all disposition of commercial garbage. In section 17101, we have a definition section. It defines trash and bulky waste to be include construction materials. While 17101 is a definition statute in general, subsection 12 of 17101 provides that contractors will be required to pick up their own bulky waste and dispose of same. There's a mandate in that particular section. This special statute does not prohibit a contractor from hiring another person to take off construction garbage. If the authors of the statute had wanted to do so, they could have provided that this was prohibited as well. The next statute that is an exception to the exclusive right of Jackson to dispose of garbage is 17103. And the one right after that, I'm going to speed up because I'm running out of time. 1032 is also an exception. Those allow the actual producers and owners of the premises to dispose of construction garbage. Nothing in those statutes prohibits them from hiring someone to do away with their particular garbage. I would like to skip ahead in my analysis or my argument to point out to the court section 17105.4. This code section is titled, it has a heading that says special requirements. This is a specific heading. It makes it a specific statute versus a general statute. And that statute provides that construction garbage and refuse shall be removed by 3 types of people. 1, the contractor, 2, the owner of the property, or 3, the person in charge. And it's our assertion that Mr. Bosco would fit within the exception of being a person in charge of the construction garbage and refuse. As co-counsel pointed out in his opening statements, I'm out of town. I'm out of time. So
We've got your rebuttal time.
Okay, thank you, Your Honor.
Yes, sir. We'll hear from the appellees.
Good afternoon, Your Honors. May it please the court. My name is Dale Condor, and I'm going to use 7.5 minutes to argue the constitutional issue, followed by my co-counsel, Ms. Luna, who will address the statute. I'd like to begin by addressing Judge Golden's question earlier to Mr. Saylor about whether the waste management should have been as a necessary party. They argue against that by saying that it was up to the city to raise this issue so the trial court could decide if waste management was in fact an indispensable party. The record shows that Bosco LLC admitted that that waste management was an indispensable party in a letter from Mr. Smith in response to the summary judgment. He identified it as an essential party. And the other point was so that the waste management could be brought in if necessary. The trial court entered an order allowing Bosco to amend its complaint and bring a third-party complaint against waste management. And in that order, Judge Atkins said that appellant's counsel was to serve waste management as soon as possible and directed that waste management be brought into the case. There was nothing more to be done by the city raising that issue, since they admitted it was an indispensable party and they were challenging the validity of the contract and wanting the court to find that the contract was null and void. As for the anti-monopoly provision of the Tennessee Constitution, the courts define a monopoly as an exclusive right granted to a few, which was previously a common right. That is a common right, a right for anyone to engage in the conduct that is at issue. In this case, it would be setting out the roll-off containers to collect construction waste. In this case, there is no evidence in the record that this was a common right at the time the city entered into its contract with Waste Management. Therefore, we believe that that this is not a monopoly and is not governed by the anti-monopoly provision, Article 1, Section 22 of the Tennessee Constitution. The city's ordinance describes who can pick up the waste, and Mr. Bosco and his company simply do not fall within that. It's either the construction contractor, the owner, or person having charge of same is the language of the ordinance. And that would indicate someone who perhaps is a lessee as opposed to the property owner having the right to pick up the garbage.
Pardon me, where is that defined in the ordinance, that language or some other person in charge has to be a lessee?
It doesn't say that person has to be a lessee. We were saying that the person in charge of same, since we have the owner and the construction contractor set out there, that would be someone who would be in charge of that property or able to pick up the waste. But the term lessee is not specifically defined as part of person in charge of same. Unfortunately, that language is not defined in the ordinance that was applicable at this time.
So clearly, because it sets out the property owner and the contractor or a person in charge, it's got to be a third party. It can't be the contractor. It can't be the owner. It has to be someone else. Would you agree?
Correct, Your Honor. I agree with that. And we believe that based on the way that the ordinance sets those out, contractor, owner, or person in charge of same would be someone there who is in charge of those premises or in some way related to the construction. For example, someone leasing the property who decided they were going to make some improvements to it, they would be included within that.
Why couldn't it be an agent hired by either the contractor or the owner to remove the waste?
I believe I think the reason it can't be is that the city wants to have control over how the waste is picked up, how it is hauled, because the ordinances deal with all of that, and where the waste is going to be taken. And so that way, the city has some idea. The construction person gets a permit or the owner gets a permit, and they know who's going to be picking this up. And so we believe it would not include the someone like Mr. Bosco, Your Honor.
Well, how does that affect the other two entities that are referenced then in terms of the contractor or the owner? There's nothing in there that sets out any qualifications for them as to where it needs to be taken or what has to be done with it, any more so than this third party would have any requirements.
And the city can designate someone to pick up the trash, and that's what they've done with their contract with Waste Management. And then they're under the nowhere to take it within the city limits to the dump that's in the city limits to dispose of that trash. So that
but I'm back to where Judge Armstrong was referencing. It says shall be removed and disposed of by the contractor, owner, or person having the same in charge. So as to the contractor or the owner, what do you say about that? What are the requirements for the contractor or the owner as far as the removal of the construction garbage and refuse under that section?
The person person who removes it has to get approval from the Director of Health and Sanitation, and that would be taken care of in those instances by the Director of Health and Sanitation, letting them know what kind of vehicle has to haul the waste and where it has to go.
And couldn't that also be applicable to this person having same in charge? Wouldn't that be the same thing, same situation applicable to them?
Correct. The person having same in charge would be, as I indicated, probably perhaps a lessee, and that person would have to get permission and get the authorization from the Director of Health and Sanitation as well, so that they would know where to take it and how it's to be transported to the dump.
Well, when you say having to get authorization, what does that mean exactly? I mean, is that something arbitrarily that they can say, that they can do? In other words, I think there was testimony in this case that someone from the either, I don't know if it was the director or someone with the Health and Sanitation Department testified and basically said that they wouldn't approve Bosco in this case because of the contract with the city.
Correct.
You recall that? That was the reason why they wouldn't approve because of this exclusive contract with the city, not because of any other reason.
The exclusive contract with the city eliminates the waste management having to deal with someone else coming in and setting out these roll-off containers. That is allowed under the city's ordinance, where the city can either has exclusive right to pick up the trash, or it can designate someone to pick it up, such as they did with waste management in their contract.
All right, thank you.
Thank you, Your Honor.
All right, we'll hear from co-counsel.
Good afternoon, Your Honors. My name is Teresa Luna, and I represent the City of Jackson, and I'm going to be dealing with some of the other issues that Mr. Condor did not touch on. But first, one thing that Bosco's counsel didn't address, but I want to address because we did not file a reply to their reply, and that is as far as the individual liability issue. I would ask the court to look at some additional statutes. We asked the court to look at Tennessee Code Annotated 763.
Ms. Luna, what you'll need to do is, if you haven't cited this before,
Right.
you'll need to file this with the court and give, of course, opposing counsel an opportunity to reply.
I will certainly do that.
Okay, thank you.
I think the facts that fit in with those statutes are this: that the misdemeanor summons that the city issued to Mr. Bosco was issued to him because it required a person's name on the summons. The statutes require a person, and that's the statute that we've cited in our brief, require a person to be cited. That person was Mr. Bosco. He came to environmental court and responded to that, and then Mr. Bosco was the one who appealed to the circuit court in his name. Then Bosco LLC filed a third-party complaint complaining about the issues of how the city had wrongfully cited them in the summons.
Ms. Lunar,
Yes.
in serving an individual in a situation like that, wouldn't it have been possible to serve an officer or agent of the LLC? And if you wanted to bring this against the LLC versus against him individually, I'm having a hard time with why it was brought against him individually, when it appears that what y'all were trying to do was to get to the LLC, since that was the business. So why wouldn't you have served an officer of the LLC?
That's a good question. And the answer is this, that the boxes, the roll-off containers, said merely Bosco. And so when the sanitation officer went to the site, he found Mr. Bosco and cited him and had to have a first name and a last name on the summons. And then Mr. Bosco signed the summons. So they have to have some person to bring into court, because that citation in lieu of a warrant requires an agreement by the person who signs to come to court without being served with a warrant. So Mr. Bosco came into court by signing that misdemeanor summons.
But he came in individually. He came in individually and not as an officer or agent of the company.
I was not there at the environmental court, and unfortunately we don't have a record of that, but he came in and represented the LLC. When we took his
Well, he-
deposition, I'm sorry.
No, I was just going to say the summons wasn't issued to him in the name of the LLC or as a representative of the LLC, though, was it?
It was not, and there's no place on there for, on the particular summons for an LLC to be noted on there. It just has a last name and a first name to be noted.
You say he represented the LLC. Can he do that? The LLC is a legal entity, and obviously Mr. Bosco, at least as far as I know, is not an attorney. So how can he do that?
Well, we asked him in a deposition once it got to circuit court and we were involved, and he said, well, Bosco and Lou Bosco and Bosco LLC are all one and the same. We are all one and the same. And if you look at the third-party complaint that the LLC filed, it assumes in that third-party complaint that it is the one that has been brought into court by the city. I think the disconnect happened when Mr. Bosco came to circuit court and appealed. Instead of appealing in the name of the LLC, he appealed in his name. And perhaps that's when the disconnect occurred.
Well, he had to appeal in his name because the summons was issued to him. And that's the way he was tried in the municipal court, was in his personal capacity, wasn't he?
Well, not in his personal capacity, but the statute requires a person to be cited, and the person has to agree to come into the court voluntarily so that a warrant will not have to be issued.
All right.
I would also like to.
So what's the effect of all that?
The effect of all that is that the correct entity was enjoined in the final order. Maybe there was a whole lot of much ado about nothing about the personal liability because the only entity enjoined was the LLC. There's nothing in the final order for Mr. Bosco to appeal from. Mr. Bosco wasn't, nothing in the final order was applicable to him. The court just found that he and the LLC were essentially the same and that the LLC should be enjoined.
Let me ask, does the city earn a fee from the placement of these roll-off dumpsters by Waste Management?
It does. It does. And that's how of course, this is not on the record, but this is how the contract works. The Waste Management and the city look at the ordinance, and the amount of the fees and the cost to the city for Waste Management to do what it does is based on the interpretation that we're giving to the court as to the ordinances at issue.
But in addition, the homeowner or contractor also has to pay Waste Management for that roll-off dumpster?
Okay, if you are a homeowner resident, you pay for regular garbage collection, which is a regular rate. But
Right.
if you have any construction work done at your house, either your contractor can haul it off or you must call Waste Management and they will bring out one of those great big roll-off containers. They're very large. They will bring those out to your house and leave it there for your contractor or you to put your debris in, and then Waste Management will come and pick it up. So yes, you do pay an additional fee because it's a very large container that they bring out. A roll-off is very large, about the size of the back of an 18-wheeler.
Okay, so the city gets a fee for that, and the homeowner also pays for that.
Well, I think that this homeowner pays the city a fee and the city pays Waste Management. That's the way the money flow goes.
Okay.
I would also like to address some of the ordinance. That was a large part of what I wanted to argue to you. But the one point I want to make is that there's just two exceptions, and my time is out. I'm sorry.
Okay.
Okay.
We've got your brief. We'll be able to hopefully glean anything we need to from there.
Thank you so much.
All right. Thank you. Mr. Smith, you've got 5 minutes.
Thank you, Your Honor. I would like to continue with the kind of where I left off in light of some of the questions that were asked by the court. Under section 17-1054, That statute clearly gives a person in charge of the construction garbage and refuse the right to dispose of same. I believe the court was asking questions, and my opponents were kind of dancing around about whether a lessee could do this or this person could do that or whatever under that statute, but the statute says what it says. And so I believe really based on section 17-105-4 alone, it's a special statute and it prevails over the general statute of 17-103. And that makes it legal and lawful for Mr. Bosco to dispose of the construction garbage. I understand that the city of Jackson, they don't want Mr. Bosco in business because the way they've got the contract drafted, they might get sued if they continue to allow Mr. Bosco to run his business. However, that's not what's at issue here. What's at issue is the statute, whether we've got an exception or not. I also wanted to address the necessary party issue. It was argued that there was that the Bosco entities, Mr. Bosco and Bosco LLC, agreed to bring in waste management, and that was provided for in a March 8th order. If the court looks at the technical record, there was an order entered on summary judgment less than 30 days later. Or excuse me, that's when the hearing was conducted. And then on April 16th, there was an order granting summary judgment on the constitutional issues in favor of the city. And so at that point, bringing in waste management was moot. We simply argue under the constitutional issue that we were denied the right to put on proof to adjudicate the state constitutional issues, and we should be allowed that. Lastly, I'd like to address the issue of individual liability. I appreciate the questions that the court was asking previously. I know that my opposing counsel, Mr. Lewis Cobb and Ms. Luna and Mr. Condor are all stellar lawyers, and the city is represented by stellar lawyers. When you're going to serve an LLC, you have to serve the registered agent or a member of the LLC. In this particular case, Lou Bosco was cited into court. That was it. And we argue in our brief, it's the first issue that we raised, that under TCA 48-217-101, there's no personal liability for the acts or liabilities of an LLC on the part of a member. Even though he doesn't have to observe corporate formalities, there's no evidence that even though he doesn't have to observe corporate formalities to enjoy the immunity provided by that statute, there's nothing in the record that shows that Mr. Bosco acted outside engaged in any ultra vires acts. There was no action by the city to pierce the corporate veil. And so therefore, liability would lie on Bosco LLC. Hold on, I'm sorry, Your Honor, I don't know why Siri is talking to me. He did not agree to be individually liable for the debts of Bosco LLC. And so therefore, we're not arguing that the court does not have jurisdiction over Mr. Bosco. The court does have jurisdiction over Mr. Bosco, but what we're arguing is that the trial court did not have authority to enter a judgment against him in this case because he's not liable for the actions of the LLC. So with all that having been said, Mr. Bosco is not liable. If you look at the pleadings, they did not serve Bosco LLC with a warrant, and so the whole case should come crumbling down. We ask the court to dismiss the entire cause of action.
We appreciate your argument. We appreciate all of you participating and working with us to keep things moving in light of this pandemic. We will attempt to get you a opinion and as quickly as we possibly can. Mr. Hibner, if you would call the docket, please.
This honorable court is now adjourned.
Thank you.
Good afternoon, all.